So you think you're going to have to file suit to secure financial compensation for your injury. That's okay. Our office handles that every day. I want to explain briefly what the process is in a personal injury lawsuit. The first thing that's going to happen, our office is going to draft a complaint. This is a document where we basically tell the judge our side of the story. We explain how you were injured. We talk about some categories of damages that you sustained. We explain what compensation we believe that you're entitled to. And then after that, we'll serve the defendant, the at-fault party. And that person's known as the defendant, and you'll be known as the plaintiff. Once the defendant is served with the complaint that you filed in court, he or she or it will have an opportunity to file what's known as an answer. An answer is just what it sounds like. It's the defendant's response to your complaint where it says, this is why I am or am not liable for these injuries. Now, occasionally, a defendant will admit, yes, I caused the plaintiff damages, and the defendant will only dispute what the extent of those damages are, how much money they owe you. That being said, it's not often. Most cases, the defendant will deny everything, and that's their right. But then we get to later use that, if it goes to trial, and show that to the jury, and all that does is inflame the jury, as you can imagine. So once the defendant files an answer, the next process is going to be discovery. Discovery is really 2 or 3 stages. The first stage being we get to serve them with written questions. Now, these written questions might ask them about, explain to us why you're not liable for these injuries. Who have you talked to witness-wise? Have you done any research on the plaintiff? You. Have they talked to any medical providers or hired any experts? Once they respond to us, in exchange, we'll have to answer some questions through this written discovery process. Then we will go do depositions. We'll take your deposition and we'll do the defendant's deposition. Now, a deposition is simply, we're going to sit down at a table, the defense lawyer, usually hired by an insurance company, me and you will sit down with a court reporter. The defendant's lawyer, hired by the insurance company, will ask you a bunch of questions. You'll say, give your answers to those questions. If I want to, I'll ask you some questions, but I rarely do. This is the defendant's opportunity to ask you questions and get answers, and we frankly don't want to give them any more information than we have to. After your deposition's done and we do the defendant's deposition, same process. Court reporter, me, you if you would like to be there, the defendant and the defendant's lawyer, and this time I'll be asking the defendant questions. Explain why you're liable, why you're not liable. Tell me who you talked to. Tell me what you know about my client's injuries, that sort of thing. When that process is over, usually we start doing depositions of any witnesses. That might be a police officer. It could be a doctor who treated you. It could be your spouse, your significant other. And the reason that we would do their deposition is to basically explain how this injury has changed your life, if at all. After we do the depositions of you, the defendant, and any witnesses, including treating physicians, we very well might do depositions of any experts that the insurance company has hired. Now, these experts are sometimes called independent medical examiners. They're hardly independent, and I have a short video explaining what these doctors are and what they do. You can look at that at your leisure. After we do these depositions, the next thing is pretrial. At pretrial, we will go with the court and we'll ask the court to exclude certain evidence and include other evidence, and the defendant will do the same thing. Once this kind of paper shuffling is done, we will set a trial date. Now, I have to be honest. Courts today want to set trial as far out as possible. And in my opinion, the reason that courts do this is because they're hoping the parties settle the case before going to trial. So don't be surprised if you get a trial date some year, 2 years after we have to file a lawsuit. You have to have that resolved because that is the status of today's legal system for whatever reason. Once we get to that trial date, though, we're going to pick a jury and we're going to do the things you see on TV, question witnesses, present evidence. And by the time we get to trial, we will have a really good understanding of the value of your case and the problems that your case might have. And we'll have explained all of that to you. During that process, leading up to trial, the defense lawyer hired by the insurance company will likely come to you with some offer. Sometimes they don't. We have to be prepared for trial. And I believe that the more prepared for trial we are, the earlier we are prepared for trial, the more likely the defense lawyer is going to talk to the insurance company about offering a resolution to your case outside of trial. So that's the process if we have to file suit. Now, after trial, we might get a great verdict and we love it, and we might get a bad verdict and we hate it. We have the opportunity to file an appeal. And I'll cover appeals in a different video, but I just want you to know that after the jury renders an opinion, it is not the end of the case. Even if it's a great verdict, and we've had great verdicts at our firm, there is always an opportunity, though, for appellate court review. That is the process from filing the lawsuit until having the jury trial.